Please.
The pretrial review is in the matter of CFI 87/2021 before His Excellency Justice Ali Madhani and is being held by way of video conference. Any orders or directions made during or after the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Dr. Hussein Law Firm LLC and the lead counsel is Sophia Hurst. The defendant is represented by BSA Ahmed bin Azim and Associates LLP and the lead counsel is Antonio Stini Plus. Thank you very much.
Thank you, Hamid. Good morning again. It's your case, Ms. Hurst.
Good morning, Your Honour. You'll be happy to hear that I think there are limited points that we need to deal with at this PTR, certainly from the claimant's perspective. The directions up to trial, I think, are what are set out in the CMC order, and I think that remains uncontroversial. I think the main matter for you this morning is the trial timetable, which there is a track change version of in the bundle at tab F4.
Yeah, I've seen it. It's red fonted.
I'm sorry, Your Honour, it's a bit, I didn't catch.
It's the red font changes.
Yes, and
See,
if I can explain what those red font changes signify. It's not a great debate or dispute between me and my my learned friend. It's really a question of whether Your Honour would prefer to build in time for oral closing submissions, or whether you prefer to deal with it in written closing submissions, or both. And essentially, the version that's crossed out was an original version that builds in some time for oral closing submissions. If Your Honour prefers not to do that and to simply have closings in writing, then we engage the deletions, as it were, and we put in the new red text, and we finish perhaps slightly earlier on the third day. I think it's right to say, certainly from the claimant's perspective, we think some oral closing submissions might be of benefit to you. It would keep the costs down if we had oral closings as opposed to written closings, but in a trial of this length, it's perhaps inevitable that Your Honour might want something in the form of written closing submissions. And so we're flexible about that, whatever Your Honour would prefer. And I think that is the defendant's position as well, but I'll let Mr. Dimitrakopoulos address you on that.
Yes, Antonio?
Yes, I do obviously concur with my learned friend that we are in your hands as to what the court's preference is. However, given the volume of evidence that's going to be adduced and the possible new twists to the evidence that might be extracted from cross-examination or re-examination, it may be best to, both for the parties and the court, to have a well thought out written submission only, as opposed to a quick on the fly kind of oral submission that is going to have to accumulate all the evidence that would have been adduced over a period of 3 days. I think that would be the most beneficial approach for all parties concerned, including the court. But as my learned friend says, we are in your hands for this.
Yes, well, I would say certainly I would prefer written submission because after the trial I got a flight, I disappeared for 10 days, and then I think from that basis written submission would be much better. So when I come back, so I can catch up all the case lines, you know what I mean, and I can make a connection. I can build my whatever. My judgment based on a written submission. So it will be, I think for me, it's much better and good things to remember. Yeah, so from that basis, I agree, although Ms. Hurst, you said it would be good also to say something. If we have a written submission, if I can give you like good length of written submission against the evidence presented, why do we need an oral closing submission? So I think I would join Antonio. I think that is a sensible way of doing this.
Your Honour, we're perfectly content with that. Happy to proceed on that basis. Just one point of clarification. In the version that you have with the track changes, I think there's a proposal to do claimant's written closing followed by defendant's written closing. In my submission, it should be simultaneous exchange of submissions rather than sequential. We don't see really any need why the defendants should follow the claimants. But other than that, we're happy to proceed in the way that you suggest.
Well, because just imagine if it happened orally, so the claimant would go first and then defendant would follow. So why the written submission did not follow that pattern, Mr. Hurst? Even how you did your how you going to do your skeleton argument? You submit it first, or it would be submitted simultaneously?
Simultaneously, Your Honour.
The skeleton argument.
I believe so. I think that's what's in the CMC order.
Yes.
Which I apologise. I'm just trying to find in the bundle.
Well, if your opponent okay with the simultaneous submission, then I'll be fine with that.
Well, as Your Honour pointed out, if this were to be an oral submission, it would be sequential. There is no reason for it to be any different. At the end of the day, we are always the defendant. We are always defending. We are always answering a claim. We have no issues to raise of our own, independent of answering a claim. So the logical thing to do is to have them sequential. However, we have made representations, I believe, to my learned friends instructing lawyers that we're fine either way. So it's not a point that we're willing to sweat too much about. We're certainly not going to come up with anything new, having had the benefit of reviewing the closing submissions of the claimant. We will still say what we feel is right to say. So if simultaneous submissions is what is the preference of the claimant, we can accommodate that. It's not an issue.
Then it's accommodated. Okay. So it's a written submission submitted simultaneously. Do you want to discuss from now like the length or the time that you need to submit, or we keep it till the end of the trial?
Your Honour, I'm flexible as to that. I can, at this juncture, I can say that the claimants would be asking for perhaps slightly longer than might usually be the case, simply because I'm in some difficulty with availability. I have a back-to-back trial after this one, so we would need a little bit more time. But perhaps it might be sensible to address this in the sort of closing minutes of trial once we've seen the evidence and we know what the issues are. Your Honour can perhaps direct us if there are questions that you particularly want us to assist you on, or that it would be helpful for us to focus on, and we'll have a better idea then of what length Your Honour requires and so on, and we can perhaps be a bit more tailored at that stage. But happy to set a date in principle if you'd be assisted by that.
Well, see, what I think, Ms. Hurst, I think, yeah, I agree with you. You would need some time. There will be a lot of evidence adduced in this, not just the witness statements, but the witness, cross-examining, but then I'm sure documentary evidence would be there. Both of you, I think, would need to comment on so many events or circumstances that would happen. Events would turn on in the trial. That would be much, much more than what I want you to address me on. So I think you would need at least a month for that, not less than 20 pages, I guess, each. I think this is what usually happens. I think I'm looking at that length of time, that length of submission. Make sense?
Your Honour, if I may address you.
Yes, please.
So I think this is probably a bridge that is best crossed at the end of the trial, both in terms of how much time we will need. Yes, we do have a number of witnesses to cross-examine, but maybe the points that will transpire quite straightforward, both in terms of the time and in terms of the length. From just an initial assessment, I think perhaps a month is a very long time and 20 pages is a very short closing submission. I think it's probably should be the other way around, but you might be absolutely correct, Your Honour. So perhaps we can you can direct us on that at the end of the trial rather than now.
What I can do now, 1 page per day. So more days, more pages. Less days, less pages. How about that?
Yes,
So 20 days. Okay.
that makes sense.
Think,
Yeah.
Mr. Hurst, I think she made a point, and I mean, she's an officer of a court. I'm sure we do really believe her and we trust what she's exactly saying. If she's caught up by heavy business, and then she might really need that kind of stretch of time. And if she said I'm fine with it, and she kind of committed it in 2 weeks, then even in 10 days, believe me, it would be fine with me. But believe me, I mean, Mr. Antonio, it takes time. That's one. Written submission, you would need to grapple with so many things, and then, you know, it's not. One would say like, oh, we already have the written, the opening submission. We have dealt with many things, but the turnover of events are sometimes quite tricky. Sometimes lawyers would prefer their written submission to be the submission that the court should rely on. You know what I mean? And believe me, I have no problem dealing with that. I would even prefer to send me, oh, Mr. Judge, just look at my closing submission, forget anything else. I said, okay, that's fine. Easier for me even. I think, yeah, between 3 of us, I think, yes, we can. But yeah, so we're looking between 20 to 30 days. Around 20 submission, maybe a little more.
Your Honor, certainly my preference would be to go for the month that you suggested. If it helps, I can tell you I've got a current commitment in trial in the DIFC in the week commencing the 14th of November, which is 2 weeks after this one. And so I would prefer to be preparing my submissions for that in the week between the two, if that makes sense.
Why not? Because you didn't know what's going on in Antonio's head. He wanted to celebrate in Christmas.
I'm happy.
Celebrate the win.
I'm certainly happy to exchange submissions before Christmas, but end of November rather than in the middle of my other trial would be preferable from my perspective.
Right.
Obviously, if we get to trial and my second commitment has settled, then that concern goes away. So perhaps we can take up Mr. Dimitrokopoulos' suggestion to revisit the precise timings when we get to trial.
Yeah, I think so. I'm okay with this. I think toward the end of the trial we can have agreement. So there is no lot of variation now between what you both propose. So I think you go in line. One thing I'm asking, one question I have in the information sheet. So the case is not fully bleeded. So. And I'm not sure, I think it's you, Mr. Hurst, who suggested it would be ready by the 25th of October, like 1 month from now. Is that right? There is anything else left apart from the skeleton argument? You're supposed to be done by today. I mean, everything submitted.
Everything other than skeleton arguments and preparing the trial bundles, I believe, Your Honour, which obviously the parties will liaise about and make sure that everything that each side wants to have included in the bundle is included. But other than that, there are no more submissions. There are no more witness statements to be exchanged or evidence to be exchanged. We are there subject to the final documents for trial.
Well, if that's the case, then I'm fine with it, because I think I have read in one of the information, the pre-trial information sheet, that until 25th, maybe you just meant, or maybe you, Ms. Antonio, who said that by 25th or 26th of October, the case would be fully bleeded.
I think
so I'm trying to find it here.
I think that may be the date, Your Honour, which we have agreed to file the trial bundle, which is the very last step in the timetable. But I'm also looking to find that reference.
Oh yes, I'm seeing it. It's Ms. Antonio's pre-trial checklist. It says, have you completed preparation? No, sorry. If not, when will the preparation of the trial bundle be completed? And then he said 26th of October.
Yes.
So you must mean the skeleton argument only, yes, Mr. Antonio?
Yes, Your Honour, in the case management order, which is tab B, tab 4, I'm just looking at that. paragraph 16 and skeleton, 16 and 17, 26th of October is also the day for skeleton arguments, written openings, chronology. All of those documents will be filed on the 26th. So that's the agreed date for the last few documents to go in.
Okay, I'm glad to hear that. So we have all we need. All documents submitted, all evidence in hand. So 26, that would give me 5 days having the skeleton before the trial, or 4 days, exactly 4 days. I think I'm okay with that. Okay, great. What else we need to discuss? If there is any other thing?
From my side, Your Honour, just a clarification, I suppose. It's not clear in the CMC order whether we're going ahead in person or remotely. I think there's an assumption that it's a remote trial, but just for confirmation from Your Honour, one way or the other.
Well, that's a good question, and I'm supposed to raise it myself. Anyway, well, if it happened, you're in Dubai, both of you, and I'm sure we do have all of the witnesses are here, located in Dubai. We do have a witness statement. We do have a witness cross-examination. I would love to have it in person in my courtroom. I think that's the best we can do, and then we can take all precautionary measures to make everyone feel safe. No problem. It won't be crowded. We didn't need a hard copy bundle. We still can use the same soft copies. So I would love to have it physical. You okay with that? Ms. Hurst, you go first.
Your Honour, just 2 points on that. I will need to confirm instructions as to whether all the witnesses are able to attend in person. I'm not sure that they had. I will need to confirm their locations and whether if they're not in Dubai, they can travel to Dubai. For myself, I'm based in London, so it will involve travel for me. That's not a concern per se in terms of sort of safety or social distancing, but I raise it because it will involve an additional cost for my client for me to travel for the duration of the trial. And if I might, Your Honour, I'll just quickly take instructions on the witnesses while Mr. Dimitrakopoulos addresses you.
Well, see, I don't need any complication if it's happened. If it's the only you who has to travel, maybe we can bring you here and we can cut 2 hours from the trial, and then we cut costs, so we break even. Ms. Antonio.
I'll have to check as well whether the defendant is who is our only witness is available. I must confess that I've been I've been so accustomed to virtual hearings, which are hugely convenient in terms of accessing everything, that whilst of course we will comply with your directions, it will require some modifications to everything that we plan to do or say and the way we're going to say it, not to mention the geographical locations of the people involved, before we can confirm that this is possible. But if this is your strong desire, we'll do our best to make it possible.
Then how about you write to me within a week from now and confirm to me? Is that okay enough? Or should be shorter, but I don't know. I don't want to rush you.
Yes, we can address you on that within a week.
Yes, certainly, Your Honour. We'll try and do it earlier than a week. I'm sure we can get instructions before then, but certainly within a week we will address you on that.
Great. Is there anything else remain to discuss at all?
Not from me, Your Honour. Thank you.
Not from me either.
Then what's left? I thank you for readiness, and I hope to have your submission in time, and also your notification about the physical trial as well by next week. And then until then, I wish you a very good time. All the best.
Thank you.
Thank
Have a good day ahead.
Thank you. Same
Bye-bye.
to you.